All right. All right, you guys, there's only just a few of us here. So if you want to leave yourself unmuted or whatever, please feel free. And then if you have any questions, stop me at any time and we can kind of jump over and answer questions as we go along. I am going to share my screen. We're going to share that. Share. All right, so you guys should all be able to see the dashboard. We're in transaction desk. We're going to go over here onto the side under the forms. And we left off last time with the domestic well water is where we stopped off at. So we are going to go into Association of Realtors. We are going to go down to domestic well water. Take off on this one. All right, now the only time you're ever going to use this is if the property is, you know, a rural property and has a well on it, whether it's a shared water or whether it's an individual well. That's the only time you're going to use this well water addendum. So you probably won't use it all that often. I've only used it a couple of times throughout my career. But it just goes through and it says the following terms and conditions are hereby included in part of the contract. So this makes it all part of the contract. The well water use addendum to the seller's property disclosure statement. Seller shall deliver a completed AAR DWWASBDS to the buyer and escrow company within 5 days after contract acceptance. Buyer shall provide notice of any SPUDS items disapproved within the inspection period or 5 days after the receipt of the SPUDS, whichever is later. So it's much like the other SPUDS. You've got 5 days. If you're the seller, you've got 5 days to turn them in, and you've got 5 days to review them. Well records. Seller shall deliver to the buyer copies of all Arizona Department of Water Resources records related to the well in the seller's possession, or notice that the seller has no such documents within 5 days after the contract acceptance. Buyer shall provide notice of any items disapproved within 5 days. Well inspection. If the well performance or well quality, water quality is of material matter to the buyer shall inspect the well and request a well inspector to send the water sample to the qualified laboratory to determine acceptability of the buyer's use. The well inspector shall verify the well's gallons per minute, pumping rate, and recharge rate during the due diligence period, if applicable. Buyer shall inform lender that the property is served by a domestic well and obtained by lender testing requirements to be performed during the due diligence period. Change of well information. Escrow company is instructed to send the ADWR a complete change of well information form and well transfer fee at close of escrow if the well is located on the buyer's property. The transfer fee shall be paid for buyer, seller, or other. You can split it however you want to. So most oftentimes on this kind of a thing with the well transfer fee, the buyer is most oftentimes going to pick up the transfer fee on it. But again, it depends on the kind of market. Right now, it's definitely going to be the buyer that would pay for it. If it's more of a buyer's market, they may ask the seller to pick it up. So it's definitely negotiable. All right, so we're going to get out of the domestic well water. And the next one that we are going to go to is, I think it's the HOA addendum is the one that we're going to go to next. So let's go back to Arizona Association of Realtors. We'll scroll down to the HOA Planned Community Addendum. So now this planned community addendum is to be filled out by the seller, not by you as the agent. And I know sometimes when you want to submit an offer, if you don't have the HOA addendum, you want to be helpful and you want to fill all this out. But by doing that, you're pretty much violating everything that this says, how this should be done. It says, number one, homeowners association information on page 1 to be completed by the seller at the time of the listing for the premises for sale. Upon completion, the addendum shall be uploaded to the MLS if available or delivered to prospective buyers upon request prior to prospective buyer submission of a residential resale purchase contract. You need to have this HOA addendum finished prior to taking a list or prior to taking an offer, because this is part of the offer. And for your offer to be complete, you have to have this HOA addendum also negotiated out. So it's very important for the seller to get this completed right off the bat. So when you're taking a listing, along with the residential seller's disclosures, you're going to give them, if it's in an HOA, you're going to give them this HOA form as well and tell them that this needs to be completed. And they can fill this out easily. They may have the information themselves, but I always highly encourage my seller to call your HOA management company and have them give you these figures so that they are accurate and current. Maybe the figures that you have aren't current. So you want to make sure that you're always getting the current figures. So Instruct your seller, call your HOA management company to get all this information in here. It's the contact information, how much of the dues, how often are the dues, if there are any special assessments, if there is one, how often and when's the start and end date, if there's a master association, or if there are any other dues or any other associations that are associated with it. Transfer fees, association transfer fees related to the transfer of title, tells them how much there are if there's a transfer fee. The max that an HOA can charge for transfer fees are, there isn't a max for those, but there is a max for the disclosure fee. So transfer fees, really, it's whatever the HOA fee or whatever the homeowners association decides they want to charge. Cap improvement fees, including but not limited to those fees labeled as community reserve, asset preservation, capital reserve, working capital, community enhancements, future improvements, or payments to HOA. There's HOA, or there could be master capital improvement fees, master associations. An example of a master association is like Anthem. Within Anthem, you've got a few different associations within Anthem, but the Anthem is the master association. So that gives you an idea of how you could have two different ones. You may have two different HOA fees. If there's a master association, most times the master association doesn't have a monthly fee, but you may have a fee that you need to pay to the master association. But there are sometimes where you will have a master association fee. It's like Sun City. Sun City has a master association fee that's paid, and then you also have your subdivision and have your associations with them with those as well. And then there's prepaid association fees, dues, assessments, or any other association fees paid in advance of their due date. And then, so you've got other fees that you can throw in there. Disclosure fees, it goes through and explains what the disclosure fee is. The disclosure fee is due, or it's to be paid for by the seller. That's not something that's negotiated out. So it's going to be paid for by the seller. Now, as a buyer, you can contribute money that would help the seller pay for those. But Arizona state law requires that that they are paid for by the seller with a maximum of $400. As part of the disclosure fees, each association may charge a statement or other document fee of up to, but no more than $50 if 30 days or more have passed since the date of the original disclosure statement or the date of documents were delivered. Additionally, each association may charge a rush fee, but no more than $100 for the rush fee if rush services are required to be performed within 72 hours after the request. And again, you've got your master association or your HOA association and what those fees are. If there are any other fees, and explain what those fees would be. Seller certification. By signing below, the seller certifies that the information contained in his notice is complete. So this is why it needs to be completed by your seller. So if it's not, your seller is the one that's going to be designating that, yes, these are the actual dollar amounts. So if the dollar amounts are different, who's going to be responsible? Seller, because he's the one that was supposed to have filled this out. So I know as an agent, you want to help your sellers out and you want to help them get this information, but the seller needs to fill this out themselves. So then you go on to page 2, it says additional obligations. If the homeowners association has less than 50 units, no later than 10 days after the contract acceptance, the seller shall provide in writing the buyer the information described below as required by the law. If it's more than 50 units, then the association shall provide them within 5 days of contract acceptance. They'll provide the things down here, information required by law. So the number there is, remember, is 50. If it's less than 50, then it's the homeowner that has to give the information to the buyer. If it's more than 50 or more, then it's the homeowners association that is required to give this information out. That's a good piece to remember there. The buyer is allowed 5 days after receipt of the information from the seller or homeowners association to provide written notice to the seller of any items disapproved. So then you've got everything down here that has to be required. Bylaws, CC&Rs, a dated statement containing telephone number and address of the principal contact for the association. It may be an association manager or a company or an officer of the association or any other person designated by the board of directors. The amount of the common expense assessment of the unpaid common expense assessment, special assessments, other assessments, fees or charges. A statement as to whether a portion of the unit is covered by insurance, a total amount of money held by the association in reserves, If the statement is being furnished by the association, a statement as to whether the records of the association reflect any alterations or improvements to the unit that violate the declaration. So in other words, if there are anything about the unit that is violating current CCNR or rules or regulations, or if there's any outstanding violations, the HOA has to provide those to you. The association is not obligated to provide information regarding alterations or improvements that occurred more than 6 years before the proposed sale. So if it happened more than 6 years before that, they don't have to provide it. Seller remains obligated to disclose alterations or improvements to the premises that violate the declaration. The association may take action against the buyer for violations apparent at the time of purchase that are not reflected in association's records. So if the association doesn't know about it, but the association then finds out about it, then they can come back after the buyer for it. If the statement is being furnished by the seller, a statement as to whether the seller has any knowledge of the alterations or improvements. A statement of case names and case numbers for pending litigation with respect to the premises or the association, including amount of money claimed. A copy of the current operating budget, a copy of the most recent financial report of the association. If the report's more than 10 pages, the association may provide a summary in lieu of the entire report. A copy of the most recent reserve study, if there is one. Any other information required by law. A statement for buyer acknowledgement and signature are required by Arizona law. So then you get into the back page. Once you have this, the seller is only going to fill out the first page of this. Once you get a purchase contract, then the buyer will take that one and fill out this page here. So this page, this buyer gets to decide who's going to pay for the transfer fees, buyer, seller, or other, or if there's capital improvement fees, who's going to pay for those. So and again, it says here, seller shall pay all disclosure fees as required by law. Again, it's required by law for them to pay them on the HUD statement or on your balance statement, but the buyer can always contribute money towards the seller's closing cost that the buyer could then, or the seller could then offset those fees. Does that make sense? All right. No answer means yes.
Yes.
Buyer verification. Buyer may contact the association management company for verbal verification of association fees payable upon close of escrow. Any current homeowners association assessment, which is a lien as of close of escrow, shall be paid in full by the seller. Assessments and liens will be paid for by the seller. Any assessment that becomes a lien after the close of escrow is the buyer's responsibility. Any other additional terms and conditions, and then the buyer acknowledgement, the buyer signs, the buyer acknowledges receipt of all 3 pages of this addendum and acknowledges that the seller has used their best efforts to identify the amount of the fees stated herein. The precise amount of fees may not be known until written disclosure documents are furnished by the association management company. Buyer acknowledges further that the brokers did not verify any of the information contained herein. Buyer therefore agrees to hold the seller and broker harmless, and fees payable upon close of escrow. So that is the HOA addendum. Any questions on the HOA addendum? All right.
What are we learning today?
We're going through addendums.
Yay.
Carolyn's here. All right. Lead-based paint is the next one we're going to go to. So we've gone through HOA, lead-based paint hazards disclosure for rentals, and there's one for sales. Make sure you use the appropriate one if you're doing a rental or a sale. We're just going to look at the lead-based paint hazard for sales real quickly here. The rental one is pretty much the same. It just has different verbiage as far as seller. It says landlord, that kind of stuff here. So it has information about lead-based lead warning. Every buyer of any interest in residential real estate property on which the residential dwelling was built and prior to 1978 is notified that such property may present exposure to lead from lead-based paint, which may place young children at risk. And it gives you the rest of the information there. I'm not going to read all that. So the seller's disclosure, and this is to be filled out again by the seller, not by the agent. The seller needs to fill this out. So most oftentimes a seller is going to say, I have no knowledge of any lead-based paint or lead paint hazards in the residence of the property. Even if it's before 78, they probably haven't had any lead-based paint studies done, so they don't know for sure. So they would probably have no knowledge. If they have had some kind of a study done, or if they know for sure that lead paint is there, then they would check that first box. And then they also need to check section B, records and reports available. Seller has provided the buyer with all available records and reports, or the seller has no reports regarding it. Most oftentimes you're going to see everybody's going to check box 2 for both of those. and then they need to initial. And then they also state here that, yes, that they know that the seller has the obligation to disclose to any real estate agent to whom the seller is directly or indirectly to pay compensation with, blah, 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 blah. Lead-based paint is bad. We all know that. All right. So the seller would initial there. And then down here, this is where the buyer would make their acknowledgement. So the buyer says that they have read the information above, and they're saying that they've read it. Buyer has received the pamphlet, Protect Your Family from Lead Paint and from Lead in Your Home. Does everybody know where to find that pamphlet? If you do not have a copy of this saved somewhere on your desktop in one of your files, it is available in SkySlope under the Office documents. So in our transaction management system in SkySlope, you can find it in the working documents section. There is a copy of that in there. So you can always get a copy of that. I would recommend that if you don't have a copy saved, save a copy of it. The thing hasn't changed in 30 years. So if you're in it for as long as Carolyn has, she's probably got the original one.
Hey, now.
Wow.
I wrote it.
She wrote it.
I wrote it.
Carolyn wrote it. All right, and then the buyer has, check one, received their 10-day opportunity or mutually agreed upon period of time to conduct their risk assessment or inspection for the presence of lead-based paint, or you've waived the opportunity to conduct it. Most oftentimes, I would say that they're going to receive a 10-day opportunity. If they've got a 10-day inspection period or whatever your they would use that time to be able to conduct their risk assessment if they change it. If you have waived your inspection period altogether, then you would check this box down there that says waive the opportunity to conduct the risk assessment. All right, agent's acknowledgement. Down here is where all of us agents will sign. Agent acknowledgement for any real estate who is getting compensation from this transaction must initial and sign. So you have to initial here for the listing agent or the buyer's agent. Cooperating agent means buyer's agent. And then down here, you have the seller signature, buyer's signature, listing agent signature, and again, cooperating or buyer's agent signature. So everybody has to sign off on this on lead-based paint. This is only if the property was built prior to 78. 78 and later, you don't need to have this. I would still suggest that if the property was built prior to 1980, I would still give them, make sure that they have the lead-based paint pamphlet, because everybody knows that they stopped selling the lead-based paint in 78 or 77, but that doesn't mean that there weren't contractors and everybody who had a bunch of paint laying around that didn't use it later on. Just make sure that you cover yourself, give them a pamphlet.
Hey Todd, it's Eric.
Hey, Eric.
Hey, quick question. I think the only thing that wasn't stated was the physical signatures needed on the lead-based paint versus electronic signatures.
Thank you very much. It is physical is needed on that, but they have relaxed that. It's supposed to be hand signed, physically hand signed, but I have seen that lax lately and they are not enforcing it.
Oh, okay.
But I would still try to get physical signatures on that if you would. That's a great point, Eric. Thank you for pointing that out.
I
Yeah.
like to send the addendum, the actual pamphlet.
Yep.
and then
Yep.
Please respond acknowledging that you received this.
It's a good idea. All right, so that's lead-based paint. The next one is going to be on the loan assumption. You guys will probably, well, I shouldn't say you probably will never use it because it hasn't been used in such a long time, but who knows what's going to happen with the market and the way things are changing, especially with how low interest rates are right now. If interest rates start to bump up, who knows, maybe one of these loans a couple of years down the road, maybe they will be, so tempting that, and if the lender will allow an assumption, you may need to have to use this loan assumption addendum. If the rates go up, maybe you want to assume the old loan at the lower rate.
I understand, but why would the lender let it be assumed?
Most lenders, yeah, Carolyn makes a good point. Most lenders right now, they are non-assumable loans. There are very few loans out there that you can assume. But if there is one that's out there, you may have to use this form. So again, loan assumption form. The following additional terms and conditions are hereby part of the purchase contract. So again, you're going to, in the purchase contract, you're going to select you're going to use this addendum. Buyer agrees to assume the existing first position loan and pay all payments subsequent to close of escrow on or before date. Any additional loan is being assumed. See additional terms and conditions on line 47. Assumption, this sale is or is not contingent upon the buyer qualifying for assumption of the existing first position no later than 3 days prior to close of escrow. I don't know why it would ever be is not contingent upon the buyer qualifying, unless the buyer was like, well, yeah, I'll assume the loan, but if it can't, I'll pay cash if they've got the ability. But most oftentimes you're going to check the box is contingent upon the buyer being able to qualify. The assumption is contingent upon the buyer's approval of the terms and conditions of the loan being assumed within X number of days of contract acceptance or receipt of terms and conditions of the loan being assumed, whichever is later. Buyer and seller agree to fully cooperate with the lender and supply the necessary documents to complete the assumption. Mortgage insurance, if the loan assumed may include mortgage insurance, which buyer also assumes to pay. Seller liability. Should seller fail to secure an unconditional written release of liability from the seller's lender for the loan being assumed, the seller will remain liable for the loan in the event of buyer's default. Seller's liability. This sale is or is not contingent upon the seller's receipt of notice from the lender indicating the lender intent to release the seller at close of escrow. If it's me and I'm representing the seller, it's absolutely going to be checked is. I don't want that to be a non-contingent thing. I want to make sure that my seller is being released. If the seller is not released from liability, seller acknowledges that the seller may have liability to lender in the event of buyer's default. Again, they just said that up here. They're telling you both places. I guess they want to make sure that you know. Due on sale clause. If the loan being assumed contains a due on sale clause or other provision which allows the lender to demand payment in full in the event of conveyance of the premises, seller's lender could call the loan immediately due and payable and initiate foreclosure proceedings, even if the payments are current, unless a conditional written of waiver of the due on sale clause is secured. So I don't want to get into a big piece of that, but that is just another thing to make sure of, is that there is not a due on sale clause in their loan, because then your buyer could be screwed. They could end up being foreclosed on immediately afterwards. So what type of loan is it? What's the current interest rate? Is it fixed? Is it adjustable? What's the loan balance? Any difference shall be reflected with down payment or whatever, date of the original loan and the loan term. So you've got all the information there about the loan. Impounds. Any impound on account shall be brought current by the seller and prorated at close of escrow. All loan cost transfer fees to assume existing loans shall be paid for buyer, seller, or split. Credit evaluation. The sale is or is not contingent upon the seller's approval of buyer's credit. If contingent, buyer shall provide the seller a current credit report and from a credit reporting agency and completed uniform residential loan application within 3 days. Acknowledgement. The buyer and seller recognize and agree that the broker are not qualified nor licensed to advise the parties as to the risk and association with their contemplated loan assumption. Buyer and seller are instructed to consult with a qualified licensed professional, including but not limited to an attorney, to ensure that they are fully understanding the risks associated with the loan assumption addendum. Because the risks associated with the assumption of a loan are beyond the scope of the broker's expertise and licensing. Buyer and seller expressly release and hold harmless the broker. So that just gets us off the hook, because we are not able to advise them on whether this is going to be advantageous to them or not. If they want to undertake a loan assumption, that's up to them. Any questions on loan assumption? All right. We're going to go back to the next one we're going to look at is the market conditions advisory. Market conditions advisory. This market conditions advisory it's not so much an addendum as it's just an advisory that is used on every one of our contracts. And I threw this in here because we use this on every one of ours. Whether you're representing the buyer or the seller, this market conditions advisory is due in our files. So this has to be signed. And really, it just states that the market is cyclical. Rates, real estate values go up and down. And we cannot predict the future. We don't know whether they're going to go up or down, and buyer or seller assume responsibility should their return on investment, X consequences, credit effects, or financial terms not meet their expectations. It's not our fault, one way or the other. So your client would sign this, or clients, whatever. They would sign this and say they understand and accept that foregoing and acknowledge receipt of this and copy of the advisory. So it just lets them know we are not predicting the future. You will hear agents say, oh yeah, absolutely. It's a great time to buy. Prices aren't going to go down. Well, again, we can't say that they're not going to go down. We can say we highly doubt they're going to go down, but as an agent, you should never tell somebody, Oh, absolutely. You should absolutely buy right now because there's no way prices are ever going to go down. Not true. Nothing is absolutely correct. All right, so that's market conditions advisory. I just wanted to bring that up real quick. The next one that we have is the multi-offer and multi-counter offer. So you've got a multiple counter offer. This is to be used if you have multiple offers that come in, and if you want to send a counter offer back out to more than one person, don't use the counter offer form. Use the multiple counter offer form if you're sending more than one counter offer back out to more than one potential buyer. Charlie talked about this in that last meeting where we actually had one where a seller's agent was trying to go quickly and they just used a counter offer form and sent it out to two different parties. Both parties accepted it, which means the seller sold his house twice. And we had to try to work out a deal where one of them dropped out, and it cost the agent all of his commission in order to make that work. So do not do that. Use this multiple counter offer form. And this goes through here and it says the multiple counter offer form is being originated by the seller to the offer or another counter offer, seller information. Acceptance of the above offer and counter offer is contingent upon agreement of the following. Seller is making one or more counter offer to other prospective buyers in the terms that may or may not be the same. You can send out multiple counter offers with different terms on each one. Acceptance of this multiple counter offer by a buyer shall not be binding unless it is subsequently finally accepted by the seller. Even though the seller sends this out and the buyers sign it and they think, great, we're under contract. No, they're not under contract until the seller agrees again that they are accepting the buyer on this one. That's to help them not sell the property more than once. If both buyers of the multiple counter offers decide that they sign it, both of them are going to think that they own the property, that they're going to be on the property. Well, not unless the seller will then pick which one of those that he's going to sign.
So to clarify, if we use this, if you're making an identical counteroffer to all parties involved.
You can either identical to all parties involved, or you could be different counteroffers back to all parties who have sent an offer in.
Would that be
This form, yes, you would use this form. So you would use this form for this offer, you would use this form and change your terms for this offer, whatever it is. So your terms are going to be written in underneath here.
So this isn't just copied and given to everybody necessarily.
Correct. Right. Absolutely. It's not just necessarily copied and given. All right. So it is subsequently finally accepted by the seller, and final acceptance is delivered per section 8M of the purchase contract to buyer's broker within the time specified. Final acceptance. Until final acceptance, all parties understand the premises can be sold to someone else, or either party may withdraw or any offer or counter offer to buyer the premises. So the buyer can back out, even if the buyer has sent in and signed it and sent in their multiple counter offer back in, they can still back out if they back out before the seller signs this and sends it back over to them that they've accepted it. Unless acceptance by the multiple counter offer is signed by the buyer and a signed copy is delivered pursuant to section 8M and received by the broker named in the contract section 9A by blank, by the time, date and time, this multiple counter offer shall be considered withdrawn and seller acknowledges receipt of a copy hereof. So then the seller would sign that. Buyer's response would be an additional counter offer or multiple counter offer is attached and incorporated by reference. So the buyer has an opportunity to not just accept this, but they can counter offer this counter offer. So it's just like a straight counter offer. You can counter offer back and forth and back and forth. What's your record for how many counter offers you've gone through? Do you remember?
Oh, it's like 5 or 6.
I had 7 once.
Oh.
I had 7 counter offers go back and forth before we finally came to an agreement. I hate that. It's miserable.
Yeah.
I would much rather have maybe 1 counter offer, at the most 2 counter offers. And then at that point, I'm like, let's iron this out and verbally. And once we get it verbally with it, then we'll get everything signed off and get it written up and get it done. So the buyer's response here, if the buyer is accepting the counter offer, they would check buyer's acceptance and then put their time back down here. Seller, you need to respond back to me that you've received this and that we are under contract by this such and such time. that make sense, guys? All right, so we're on to page 2 of it. Seller response. So the seller's response to this is that either their response is to counteroffer back to your counteroffer, or they are going to accept your counteroffer back. Again, we can go back and forth unlimited amount of time. But so the seller has 2 options. They're either accepting the counteroffer, or they are offering another counteroffer back again. Make sense? All right, good. Done with multiple counteroffer. Now we're going to go back to multiple offer counteroffer. Yeah. I looked at this about 3 times and my eyes crossed and I was like, what am I not seeing here? So multiple offer counteroffer. This is going to be used by you as a buyer's agent if you are making multiple offers on properties and your buyer is only planning on buying one of them. So if you're making multiple offers, you would use this form. I can tell you that probably 95% of the agents out there in this market with their buyers are not using this form when they're submitting multiple offers for their buyers. They're throwing out multiple offers all over the place without using this form to notify the seller that they are putting out multiple offers. What would be the reason why people would not want to use this form?
To show that they're more serious.
Yes, kind of. You're on the right lines. But if you are a seller or if you're a buyer's agent and you're writing multiple offers for your buyer, by legality, you are supposed to be notifying them that you are submitting multiple offers on multiple properties because your buyer cannot buy more than one property. They're not qualified. If you throw out 3 offers and all 3 of those get accepted, your buyer's toast. He may be in trouble for, he may end up having to owe earnest money and lose money on some of that stuff. Or a seller could come back with repercussions on him because they've accepted your offer and you didn't go through. It's just much better if you do use this form for your buyer. But a reason that people are not using it is because sellers are looking for the cleanest offer possible. And an offer where you've submitted multiple other offers does not seem like it's very clean. It's very much an opportunity for them to be able to get out of this. So it's not as strong of an offer for a buyer if you're using a multiple offer form.
One would argue that if you got all 3 accepted, you simply cancel 2.
You could simply cancel 2 of them during the inspection. But number 1, you're being dishonest.
I'm not saying I've ever done that.
No, none of us have ever done that. No, absolutely
I'm
not.
just saying
You could. One could effectively do that, but you're being dishonest. And if something were to happen where, God forbid, you cancel one of the other offers wrong, your buyer's in trouble. So just be careful. Be very careful. Use this form if at all possible. Use this form, period. Acceptance of the above counteroffer is contingent upon the agreement of the following. The buyer is making 1 or more offers to other prospective sellers in terms that may or may not be the same contained here within. Acceptance of this offer by seller shall not be binding, and it is subsequently finally accepted by the buyer, and the final acceptance copy is delivered per section 8M of the contract to the seller's broker within the time specified. So again, see here where we have that issue. What if the seller, you submit your offer to the seller and the seller accepts your offer, you're under contract. Where if you use this form, this still gives your buyer the opportunity to go, yeah, nope, I know I've submitted multiple offers. I don't want to take this one. I'm not pursuing forward with yours. So that is really why it helps your buyer. Unless accepted by this multiple offer offer is signed by the seller and signed, copy delivered pursuant to section 8M, the contract, blah, 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 that shall be withdrawn and the buyer acknowledges receipt of the copy herein. So that's your buyer's option if you're submitting this with your offer. Then the seller's response is here. Either the seller is going to counteroffer you or the seller is going to accept your offer. And then the buyer's response back to that again. That's the final acceptance, or they would counteroffer back again and you would keep going back and forth with your offer and counteroffer again. Make sense, guys? All right. So we are done with that one, multiple offer, counter offer. Let's go back and see what we have next to go through. Where are we at? 136, we got lots of time left. Multiple offer, counter offer, mutual cancellation, notice of abandonment, notice of cancellation of property management agreement. We don't want to do any of those. Notice of renewal of lease agreement. I don't think we need to go through those. Those aren't addendums. We're only looking at addendums right now, things that we might have to use. Notice of disclosure, on-site wastewater treatment facility addendum. That one we're going to take a look at. So on-site wastewater treatment facility, what is that used for? Septic, absolutely correct. All right, so this is the addendum you will use if there's septic on the property. Now, remember, guys, that there are places with septic all over the valley, not just on the outside of town. Lots of places in town where you would swear that they're on city services are on a septic system. So you just need to make very careful sure that you're using the right forms and declaring the right things for your clients. So the following additional terms and conditions are hereby included as part of the contract. One or more on-site wastewater treatment facilities have been installed on the property. The Arizona Department of Environmental Quality rules require a pre-transfer inspection by the seller. Facility inspection. Seller shall have the facility inspected at the seller's expense within 6 months prior to the close of escrow, but no later than 20 days after contract acceptance. The facility inspection shall be completed by an inspector recognized by the applicable government authority as qualified to inspect the facility. Conventional septic system pumping. If the facility is a conventional septic system or alternative system that uses a septic tank prior to close of escrow at the seller's expense, they shall have it pumped. Have it all possible. This is just gross. All possible solid, floating, and liquid waste accumulations, unless a discharge authorization for a facility was issued and the facility was put into service within 12 months before the transfer of ownership. Pumping or service is not necessary based on the manufacturer's written operation and maintenance instructions, or no accumulation of floating or settled waste was present at the septic tank and wastewater container. Disgusting. Accumulation of floating or settled
Stop it.
waste. Why do we have to have floating?
You
Come
don't
on.
have to repeat it.
Document delivery. Within 20 days or blank days after the contract, the seller shall provide the buyer with a report of inspection form completed by the qualified inspector and any other documents in the seller's possession that relate to the permitting or operation of the maintenance of the facility. Repair cost. If the facility is not functional per the report of inspection and cannot be certified by the applicable government authority, the seller shall pay to repair the facility, provided that such repairs do not exceed 1% of the purchase price. If the costs exceed 1%, the buyer may immediately cancel the contract. The seller may cancel the contract unless the buyer agrees in writing to pay such costs in excess of the amount that the seller is obligated to pay. So that's kind of a key piece there, that number 2. The buyer may cancel, or the seller may cancel if the buyer does not agree to pay for it. So that's not a free out for the seller. The seller can't just cancel. If the buyer says, no, I still want to buy it, I'll take care of the septic system, the seller can't cancel out based on that. So that's a big piece to know in there. It's not a free out for your client, for your seller. If the facility is functional with concerns per the report, buyer and seller acknowledge and understand they may, but are not obligated to engage in negotiations for repairs to the facility. Buyer disapproval. By delivering to the seller a signed notice, buyer may cancel the contract within the inspection period or 5 days after receipt of the facility documents, whichever is later, and be entitled to return to the earnest money prior to expiration of the specified time frame. Buyer and seller may, but are not obligated to engage in negotiations for repairs to the facility. Buyer's failure to deliver a signed notice of cancellation to the specified time period shall conclusively be deemed buyer's election to proceed. So if you don't cancel, it means you're going forward. Notice of transfer. A buyer shall deliver to escrow company a completed ADEQ notice of transfer of ownership of an on-site wastewater treatment facility form prior to close of escrow. Escrow company is instructed to file the notice of transfer and filing fees with the applicable government authority at close of escrow. The filing fee is negotiable. It can be paid for buyer, seller, or split evenly, or however you want with any additional terms in there. Pretty straightforward, guys. There's just a couple of things in there. That one about the seller not being able to cancel on their own, I thought was a big piece in there. Anything else that we want to talk about with this?
So does that mean he has to pay the 1%? And if it's more than that, the buyer can negotiate to pay over the 1%? Or
If
does
it's-
or does it say, it says, over an amount the seller agrees to pay, but is the seller obligated to pay at least the 1%?
That's a great point. That's a great question.
Okay.
So I would say
It
yes.
says shall or shall.
Guess what?
It says shall.
Yep. It's because it says buyer agrees in writing to pay such cost in excess of the amount the seller is obligated to pay. Seller is obligated to up to 1%. So that would mean the seller would cover up to 1% of the purchase price and the buyer would cover anything over that. And the seller is obligated to pay that. That's not optional.
That's just if it's not functional.
That's just if it's non-functional.
Doesn't pass the test.
Right.
So how do you know, unless you're relying on the seller to tell you, yes, there's a septic system here.
Yeah.
That's how you know.
Pretty much, yeah. You're going to be reliant on the seller's knowledge of whether or not there is one on there. And most oftentimes it's going to be filed. There's going to be a record at the county if there's a septic on there. So if you do a title search on it, you should be able to locate some document that would tell you whether or not there was septic installed on the property. We had one recently where it was a lot down in around Maricopa that the seller was selling and did not disclose the fact that there was a non-working septic from God knows when on the property. There was nothing else on the property. I think it was probably for a trailer house that was on there. So now they're selling the lot and there was a septic on there and they didn't disclose that there was septic on it. And the buyer did not know that there was septic on it until they got through the inspection period. And then they finally discovered that there was a non-working septic on the property and the seller didn't want to provide any information on it. So the buyer wanted to cancel and the seller said, fine, I'm going to keep your earnest money because you're past your inspection period. So it became an issue where we went back and forth with that one. And it finally turned out that the buyer got their money back and was able to cancel and get out of it.
Is there any possibility that the seller doesn't know it's a septic?
Sure.
Yeah.
Yeah, there have been cases here where in Phoenix, in proper Phoenix, like in some of the older neighborhoods in here, where the seller was absolutely 100% convinced that they were on city services. And it turns out they were on a septic tank. Yeah.
Just never got
Yep.
updated, yeah.
Yep, absolutely. Okay, wastewater treatment facility is done. Let's go to the next one.
That will be discovered in title.
It should be discovered in title, yes. And that's another great reason why I'm going to promote again why we use legendary title here is because Justin will get that report to you quickly. And you can always ask Justin, hey, is there anything on here I should be worried about? And she can do a quick look at it and give you some ideas. All right, so we just got through wastewater treatment. Where was that? On-site wastewater treatment. Pre-qualification form, we're not going to go through. Property management, we're not going to go through. Agency disclosure and election. I'm just going to jump into this really quickly. You've got a buyer and seller one here, and I'm just going to jump into this real quickly because we've got a couple of newer agents on here just to go through the form again. I'm not going to read through the whole thing, but just kind of go through and just give you some highlights on it. So it's the agency disclosure and election, and it just says the buyer's broker, a broker other than the seller's broker can agree with the buyer to act as a broker for the buyer. In these instances, the buyer's broker is not representing a seller, even if the buyer's broker is receiving compensation for the services. Seller's broker, it goes through and it gives a definition of what a buyer's broker and what a seller's broker is, and what a buyer representing both buyer and seller, what their obligations are and what their limitations are. So read through this. It's always good to know these things. But going through this is always a piece I like to go through here. Regardless of who the broker represents in the transaction, the broker shall exercise reasonable skill and care in the performance of the broker's duties and shall be truthful and honest to both the buyer and seller to disclose known facts which may materially or adversely affect the consideration to be paid. Pursuant to ARS 32-2156, sellers, lessors, and brokers are not obligated to disclose that the property has been 1, the site of a natural death, suicide, homicide, or any other crime classified as a felony. 2, owned or occupied by a person exposed to HIV or diagnosed as having AIDS or any other disease not known to be transmitted through common occupancy of real estate. Or 3, located in the vicinity of a sex offender. Sellers representatives may not treat the existence, terms, or conditions of offers as confidential unless there is confidentiality agreement between the parties. I'm going to repeat that. Seller or seller's representatives may not treat the existence of terms and conditions of other offers as confidential unless there's a confidentiality agreement between the parties. So,
See, it says right there, we didn't ever need that stupid thing to be included
Exactly.
in the listing
we
agreement.
didn't need to have the ER redone because it says right here, unless this has changed, which I don't think it is, this isn't a new form. And what this says is the seller's representative, you as the seller's agent, have the right to disclose the terms and conditions of other offers that you've received to potential other people who are wanting to put an offer in. So now we, and in the ER form, we have an actual box that we have to check that says yes or no, we can disclose these facts. Well, it states right here that I have the opportunity to do that. So now if we fill out the ER form and we check no, it overrides this.
So we've just shot ourselves in the foot, essentially. And I tell you that 7 out of 10 agents will
Never read that line.
never read that line
Yep.
and insist that they are not allowed to disclose.
Yep.
Yeah, and I argue with them each and every time.
Yep.
Yeah.
So this would come into play if I'm the seller's representative.
Yep.
And I've got a full price or over full price offer.
Right.
I
Right.
can tell another
Potential buyer, if they're thinking of putting an offer in, you need to beat this in order to, to make it work. So yeah, that's what gives you that authority.
And I tell you why you want that, especially in this market. If you've got, so we had a house listed at 375. By day 2, we were up in the 440s. If we hadn't have been disclosing that number, we'd have had
100
30
offers.
more offers at 375 that we'd have then had to have dealt with.
Right.
So it saves everybody a lot of time and aggravation.
Okay.
All right. So the duties of the broker in a real estate transaction do not relieve the seller or the buyer from the responsibility to protect their own interests. The seller and buyer should carefully read all agreements to ensure that the documents adequately express their understanding of the transaction. Now, this is down here is what is the pieces that you really need to know. So if you are representing a buyer, you are going to say, I'm going to represent you as the buyer's broker, and we are allowed to show properties that may be listed by my brokerage, by other agents within my brokerage. So that would make it a dual agency if we did that. So you want to check that box so that it allows you to show other Berkshire Hathaway listings. Otherwise, we may not, if they say, no, I don't want you to check that, I don't want dual agency, well, then I can't show you any other Berkshire Hathaway properties. So we don't want to do that. So that's if you're representing the buyer. If you're representing the seller, you're going to represent the seller as the seller's broker, and you're going to show seller's property to other buyers. So that, again, that will allow you to be the dual agency thing there.
How often does that happen?
It fairly often, and especially in today's market where the inventory is so limited that there are buyers just crawling out of the woodwork trying to get to the house first. So they're coming straight to the selling agent, also thinking they're going to get a better deal if they can eliminate another agent on the other side. So there's a lot more dual agency. All right, so the undersigned buyer or seller acknowledges the document of their duties, blah, 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 blah. This is not an employment agreement. What is an employment agreement? An ER form is an employee agreement. What is another employment agreement? A buyer-broker agreement is also an employment agreement. So those are employment agreements. This is just an acknowledgement. ER is the exclusive right to sell form for a seller. All right, so we've gotten through that one. It is 1:50. We've got a little bit more time left. Let's see how much more we can get through. We should be able to get through almost everything else. Let's see. We got agency disclosure, referral fee. I'm not going to go through the referral fee, but guys, you guys make sure you're familiar with this referral fee agreement, because this is where you can find it, fill this out, and give it to Charlie to have him sign off on, and then send it to the other brokerage so that you can get referrals if you're referring somebody from another area. Yes, Eric.
A quick question, just to play kind of a devil's advocate. Is there any sort of confidentiality agreement terms on the listing agreement that could be kind of, I guess, hold its value to the argument of not being able to disclose any other offers?
Yeah, there's a section in the ER form now. It's that new section in the ER form that says, no, do not disclose.
But even before that, was there something? No, there was
No,
nothing.
it was not before then. So that was what Carolyn was saying before, that she argued before that we had the right to do this, and other agents kept arguing with her that no, you did not have the authority unless you have written permission from them. Well, we had written permission from them in that agency disclosure form.
Understood. Okay, sorry about that. Thanks.
Okay, nope, no problem. All right, request for loan information, residential buyer's inspection notice and seller's response. That's not an addendum. We're not going to go through that. Residential income property addendum. I'm not going to go through income property addendum stuff right now. We'll do that at a later time. Lease property disclosure statements, seller financing addendum, non-credit, seller financing addendum, short sale addendum. I do want to go through a short sale addendum, guys, because we may start running into some of these again. So you've got short sale addendum to a listing contract, and you've got a short sale addendum to the residential purchase contract. And I'm going to go to the purchase contract one real quick first. So for those of you who are not really, aware of short sales and how they work, it's really what you're saying is that the property is selling for less than is owed on the property, and it has to be okayed by the lender. So the following terms and conditions are not hereby included in part of the contract. Delivery of all notice and documentation shall be deemed delivered and received when they're sent. Contingent upon an acceptable short sale agreement, buyer and seller acknowledge that there is more debt owed against the property than the purchase price. Therefore, the contract is contingent upon the agreement between the seller and the creditor, acceptable to both, to sell the premises for less than the amount. Buyer and seller acknowledge that it may take weeks or months to obtain creditor approval. Nothing shall limit seller from accepting subsequent offers from subsequent buyers and submitting backup contracts to seller's creditor for consideration. The parties understand and agree that the seller's creditor may elect to allow seller to sell the premises to only to the holder of the contract with terms and conditions most acceptable to the creditor. Documentation to creditor. The seller shall submit to creditor a copy of the contract, including this and other addenda and any other documentation required by the creditor for approval of the sale within 5 days after the contract. Seller agrees that to diligently work to obtain a short sale approval and promptly provide the creditor with all additional documents required, including an appraisal at seller's expense if required. Seller instructs creditor to provide approval status updates to the brokers and buyer upon request. Terms of acceptance agreement notice the seller. If seller and seller's creditors enter a short sale agreement, seller shall immediately deliver notice to the buyer. Time periods. The date of the seller's delivery of the short sale agreement notice to the buyer shall be deemed as the contract date, not the date that it was written or the date that you guys agreed to it, but the date that the short sale agreement is given to the buyer is now day one of the contract. Escrow and earnest money. Buyer shall promptly open escrow with the deposit of earnest money as described in the contract upon receipt of the agreement notice. So you don't, as a buyer, you don't have to deposit earnest money into escrow until you get the approval notice from the lender. That's something that's kind of new, because back when I did short sales back in 2008 and 9 and 10, you deposited earnest money right away. And then you waited maybe 6, 8, 9, 10 months, a year and a half down the road before you'd finally get an answer back.
Not only that, remember the lenders started requiring the earnest money to be non-refundable for 90 days.
Yeah. So that you can back out and jump to another one.
Back out and go to a new house.
Yep. Close of escrow shall occur 30 days or blank days after delivery of notice of agreement. So creditor requirements. Buyer and seller agree to cooperate with creditor and sign additional creditor disclosures or execute additional addendums required by the creditor as a condition of the approval of the short sale, provided the buyer and seller incur no additional cost or liability. Buyer may unilaterally cancel this contract by notice to seller at any time before the receipt of the short sale notice agreement. Legal and tax advice, consult somebody more appropriate than yourself. We are absolutely not qualified for that. Unfulfilled contingency. In the event that the seller and seller's creditor are unable to reach a short sale agreement acceptable to both, at the sales price contained herein, seller shall promptly notify the buyer of the same, and the contract shall be deemed canceled due to the unfulfilled short sale contingency. If applicable, the buyer shall be returned to a refund of their earnest money. In the event that any provision contained in the addendum conflicts with whole or part of the other terms of the contract, the provisions of this addendum shall prevail, and the conflicting terms are hereby considered deleted and expressly waived by the buyer and seller. So just something to make sure that, I just wanted to make sure you guys are aware of it. We may see some at some point if property values decline, and we're not anticipating any of that, but if they decline, we may start seeing some short sale stuff again. But All right, we're at 156. Was there anything else that I wanted to go through today? We've gone through short sale, unfulfilled loan contingency notice, vacant lot, vacant land, wire fraud advisory. No, that's pretty much it. That pretty much covers all the other addendum. Is there any questions or any other addendum or anything that you guys want to cover? All right, so I'm going to stop sharing. We're going to be back to our screen. So we got a few people here today. Yay. Well, thanks for coming in, guys. That's all I have for today. So we're going to finish it up here. Next week, I am going to be out on vacation, so I will not be here next week for class. The following week, I am going to say yes, we are going to have it. I can't tell you what it's going to be on, but I'm going to say yes, the following week we will be having class. So that will be the 5th on the 6th, 7th. 7th is a Wednesday. So July 7th will be the next class that we have. And I will come up with the topic sometime before then and let you all know. All right, that's all I have, guys. Have a good afternoon.
Thanks, Todd.
Thank you, Todd.
Welcome. Bye.